You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. My name is Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This is episode 142. What is the printed matter doctrine and why you can't patent your book? In this episode, I'm talking about a doctrine in patent law called the printed matter doctrine. And there was a recent case that came out that clarified this doctrine a little bit, but it didn't really change the basics of what this doctrine is about. What the printed matter doctrine is, it's a principle that printed material is generally not patentable subject matter, and it's based on the idea that presenting information in printed form does not contribute to the technological arts in a meaningful way. If the only thing that is different are the printed instructions or labels or other informational content without any innovative technical feature, then it's not eligible for patent protection. It's probably easier if I gave you some examples. Let's say you wrote some instructions on a piece of paper, or you wrote down a method of playing a board game, or a recipe book, and you want those things patented. And the only new thing is solely that there's printed matter. Then you're not going to get a patent on it because you're not improving the paper that it's written on. Another example from a real case, if there's a medication kit and the medication kit existed before, but you put on a label on that kit to say how to take that medication in the best way. So you try to claim the medication kit with a label having that information, and that's not going to be patentable, even if the information on the new label is new and non-obvious. This is what happened in the case called AstraZeneca v. Apotex, where the labels provided dosage information, and that's not going to be patentable. Now, this is not to say that you might not be able to get a patent on a new method of treating a disease. This is just to say that you can't get a patent on the physical object of the medication kit if all that's different about the kit is printed information that you now included on it, because that printed information is just informational and it doesn't really technically advance the kit itself. The key distinction is whether the printed matter provides a technical contribution or functional improvement beyond merely conveying information. If it does, it may be eligible for patent protection. Let me give you examples of what has been allowed. There was a case of Miller in 1969 where there was a measuring cup and it had markings on it that allowed for easy calculation of partial recipes. That was considered patentable because the writing on the cup made it so the cup itself was more useful. It improved the cup. That's different than just putting information on paper, because instructions are not improving the paper itself, but written material on the cup is improving the cup. So there are really two key questions in the printed matter doctrine to see whether it applies. So it's a two-step test. First, is the claimed limitation directed to printed matter? If it's not, you don't even need to go to step 2. But if it does, then the second question is, does the printed matter have a functional or structural relationship with the associated physical substrate? In the new case that came out this year called IO Engine, the court said that claims should only be rejected if the claims were explicitly directed towards the communicative content. The case itself was pretty technical. It had to do with securing communication for portable devices using a tunneling client access point, and part of the claims required encrypted communications and program code. I'm not going to go into all the details, but the examiner and the patent office at first rejected it because encrypted communications and program code, they said they were basically analogous to printed material. But when it was appealed to the Federal Circuit, the court said that encrypted communication and program code in this case were not printed matter because they did not claim the content of the information. So they weren't claiming the information itself. So what the court basically did is that it narrowed the printed matter doctrine to exclude only explicit communicative content such as instructions or specific data, while allowing claims related to communication formats. They weren't trying to claim the content of the information in this patent. The encrypted communication and the program code were part of the act of communication, and that's okay to have in the printed matter doctrine. Doesn't apply in this case. If you want all the details, you can look up one of the patents in the case, which was U.S. patent number 853047. And there's lots of blog articles about it. But unless you have a computer engineering background, it's probably difficult to understand what's going on. But in the end, what this might mean for other inventors is that if it's a close call on whether something falls under the printed matter doctrine or not, you probably have an easier chance to get it allowed if it's not just mere information that you have on your product. Mere information still isn't going to be allowed, but if it's more than mere information, that is the printed matter part, then you might be able to better argue that the printed matter doctrine doesn't apply. So if you have something printed on your invention and you think that printed part is part of what makes your invention innovative, ask yourself whether what's printed on it is making the product itself better in some way, like indications on a measuring cup to help you measure better. Or is it just providing information about how to use the product, like instructions on a medication kit? Now, just to be clear again, even if the printed matter makes the product better, it doesn't mean that you'll get a patent on it. You still have to pass the novelty and non-obviousness test. And this episode is really about whether you can pass the potential initial rejection due to printed matter doctrine. Hope you enjoyed this episode. And until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.